All right, and how's everybody doing today? Hopefully you guys are doing well.
Great.
We're gonna go ahead and get jump started on a couple of kind of ongoing issues that have occurred, and also some information that is a couple of changes that are going to be made and have been made on the MLS. So I just wanted to make you aware of not only the reasons why the changes have occurred, but also can prepare when those changes actually do happen. But before I jump in and talk about any of that, any questions offhand that you guys have been needing an answer to that I could jump in real quick and try to answer? And if you want to, we can save that for the end as well. But I just wanted to give everyone the opportunity to ask any question that they may have. So anything that's pressing for anybody. And I will take silence as a no. And so if that is the case, then we can certainly just jump right in. So, okay, I'm going to jump in by sharing my screen. And okay, so this is nothing that is new for anybody, but the reason why I'm bringing it up is because we have had, just in the last 2 weeks alone, we've had 2 separate transactions where the agent in our office did not get this form signed, and the client, of course, is claiming that they didn't know that earnest money was non-refundable. So as a reminder, we came up with this form, this non-refundable earnest money contingency waiver, a couple of months ago. I want to say 2 or 3 months ago, because the industry was going pretty crazy, where people were waiving their due diligence, waiving their appraisal, waiving the financing. They were putting non-refundable upon acceptance, and because that's really the only way that you could get your offer accepted. And clients, of course, when we represent the buyer in those situations, the buyer's like, sure, whatever I need to do to get my offer accepted. I need to get a home. And then they go under contract. All of a sudden, the home isn't what they thought it would be. They're wanting to cancel, which they can cancel in some situations if they have the right to cancel because they didn't waive all their contingencies, but they may lose earnest money. Or if, in some examples, and this was one of them that I'm talking about in the last couple of weeks, is one of the offers, the buyer waived all of their contingencies. And so right when that offer went under contract, even though that wasn't disclosed that there's non-refundable earnest money, the buyer didn't have the right to cancel the contract at all without being in default. And so right when their offer was accepted, their earnest money automatically became non-refundable. And so someone was reaching out to chat. So if you have a question, please just take your mute off and go ahead and ask it upright. But so in that example, the buyer, they were choosing not to bring the earnest money in because they changed their mind. They wanted to cancel the contract shortly after they went under contract, and they just said they were not going to bring the earnest money in. And I even talked to the client, and told them that, hey, because you waived all of your contingencies, your due diligence, your appraisal, your financing, which the agent claims they went over extensively. Well, of course, the client is claiming that they never would have waived their due diligence. They never would have presented an offer that way. And this form is there to help protect you when the client claims that you did not disclose this with them. So, because then I can go back to that buyer and show them not only that they signed the offer, but now I can show this additional form. And in these bold letters, buyer understands and acknowledges that submitting an offer of purchase that includes payment of non-refundable earnest money means the buyer will lose their earnest money if they cancel, regardless of the reasons for the cancellation. The company advises buyer to seek their own professional counsel that could include, but is not limited to, their own attorney, account, etc. Prior to submitting such an offer, buyer agrees to hold the company and the agent harmless from anything resulting from submitting an offer of purchasing with the payment of non-refundable earnest money. And we've extended this to even include any waiving of the contingencies. So we've given you opportunities to explain this. So what we're trying to make sure that you guys do is, heck, if you want to have your buyer sign this every single time when you get documents signed up front, because you don't know what type of offer you're going to have to present, I would encourage you to do that. Have them get this signed, explain what it is. And if you make an offer that doesn't waive contingencies or non-fundable earnest money, fine, so be it. So they signed something and they got more information. But if you did come across an opportunity that you needed to waive a contingency or offer non-refundable earnest money, now you've got this to protect you. Any questions about this?
I was just curious, are you still seeing a lot of non-refundable earnest money? Like,
yeah, so the great question, Keith. The two that happened in the last, again, this was last week, it happened twice. One of them had non-refundable earnest money at the very beginning of the offer. The other one, they just waived all of their contingencies because it was a cash offer. And because they didn't have the right to cancel, their earnest money wasn't able to be given back to the buyer. So it was treated as non-refundable.
okay.
But yes, we are still seeing them. So make sure you're using this. If you come across anybody that is, if you're hearing stuff, make sure people get this filled out. It's going to be a huge lifesaver for them. I promise you. Okay. All right. Next, you may have noticed this if you've logged into the MLS. There's a change that has now or will be going into effect effective September 1st. And that is the language that you're used to seeing as off market. That language is changing from off market to active no show. All that's changing is the title. The use of what that was intended to be used for is not changing. Okay. So they said, why the change? We've received many requests over the past few years to clarify the meaning of off market. At its core, off market status was meant to convey to the members that the property has an active listing agreement in place. However, showing appointments are not permissible due to a variety of factors. So the way that off market was supposed to be used is we still have that listing. It's just the seller's not allowing showings at this time. So why it was confusing for a lot of reasons, but we had agents, when they saw an off market status, they were calling up the seller directly thinking that the listing was now available to try to, they thought it was an expired listing basically. So agents were calling up the seller on an active listing and soliciting for business, which is not only an ethics violation, it's a division violation. So the MLS and the board of directors there, they felt that if they changed the title of what was being shown, that will be less confusing. So hopefully it is. It's an active listing. It's just not on the market being shown.
Rob, I have a question about that.
Yeah.
What is the difference between that? So if it then a withdrawn, is the withdrawn kind of that same thing, that it's withdrawn from the market but the listing is still with the brokerage?
So the
A
difference,
conditional.
yeah, conditional. Well, I know for our company, we still have the conditional or unconditional withdrawal form, but just so you know, on the MLS, that language does not exist anymore. They have withdrawn or canceled. So just making sure that we're talking about the same thing. Withdrawn on the MLS is what used to be considered a conditional withdrawal. That's the same status. Withdrawn equals conditional withdrawal. Cancellation is what used to be an unconditional withdrawal. So let me explain the difference of the two. An unconditional withdrawal, or what is now known as a cancellation, is that listing is no longer with our brokerage. They could list the property with any other brokerage as they see fit. So it is, we do not have the listing, it's off the MLS, everything is done. A withdrawn or a conditional withdrawal means that we still have the rights to the listing, but now it's not marketed at all. So meaning that we are not actively marketing the property because the client has decided that they don't want to sell the house anymore. So we've just taken it off the market. So it's off the MLS. We're not going to anybody in our company and saying, hey, yeah, I've got a home that's for sale, because it's not for sale anymore. But what it does is we still hold onto the right. If the seller changes their mind, we still own that listing. Off market is still active and it's being marketed. They're just not allowing showings. Does that make sense? Jeanette?
Yeah, that does. Perfect. Thank you.
Okay, you bet. Any other questions about that? Okay, let's go ahead. Let's go ahead and next. Okay, I'm addressing something that is going to be making a change with the MLS. And my guess is it'll be effective probably in the next 60 to 90 days. But I want to cover it with you first and help you understand the reason why and what it involves. Okay, so I'm sure you got, some of you may be on this call. I don't know, but I'm sure you've all seen it before, where an agent is trying to get their listing out on promoted out to the consumer and make it appear that it's a brand new listing. And so what they do is they cancel their listing and then they relist it so that on the MLS they can get 0 days on market. You guys have seen that before, right? Okay, I'm going to take silence as a yes.
Yes.
Okay, thank you, Jeanette. So what you also still see on the MLS is you're going to see DOM, which means days on market, and CDOM, which is cumulative days on market. So what are the difference? Days on market, it relates to, it's MLS number specific, and it is factoring in, as you can see on this slide right here, that it is based off any active or backup listings. The status on days on market will pause if the status has changed. What was formerly known or will be formally known on September 1st as an off-market status, it goes to an active or no-show, or if it goes to withdrawn, or if it goes to under contract. That's where the days on market pause. It no longer is still calculating to see how long it's been on the market. And that number, the days on market, would reset if the listing either was canceled, it expired, or it was sold. That's when the days on market would start over. However, continuous days on market or cumulative days on market, they would only reset based on totally different status. The cumulative days on market was tied to the tax ID number, not the MLS number. And then the value carries over from a prior listing unless the reset event occurs. So meaning if you were to reset this listing, unless it meets one of the reset criteria, then this continuous or cumulative days on market would continue. So you could have CDOM of 60 and DOM of 1. That's because somebody has gone in and reset days on market. Okay. The days on market continue to move forward if it's an active listing or if it's backup. It'll pause if it has an active, withdrawn, or under contract. So those two things are identical to days on market. But this was the difference. It would reset if the property sold, if a certificate of occupancy was provided, or it was taken off the MLS for a period of 90 days. That's where this CDOM would reset. So again, we would have agents that they got, in this last market, believe it or not, we would have agents that have a listing on the market for a week. They would want to go, they'd resubmit, they'd cancel the listing because they'd resubmit it because they want to make it look like it's a new listing again on the market, when in reality it's the same listing that was there. And so CDOM would have been showing 7 days and DOM would have been then 0. Does that make sense?
Yes, it does.
Okay. Thanks, Christopher. Okay, let me, so that's what's currently happening. And let me go to what's going to be moving forward. Here's a summary of the changes. The current DOM and that model is going to go away. And the CDOM is going to become the new days on market, the new DOM. So the model of what used to be considered for DOM, this is going to go away. And we're going to be held more to this standard, but there's going to be a minor change to it. The listings will reset after 30 days instead of 90 days. So we're no longer going to have both the DOM and CDOM. We're only going to have DOM, but it's going to be based on this criteria at 30 days instead of 90 days. So it's going to look more like this. It's going to be more simplified. It's going to be tied to the tax ID number. So if an agent goes and cancels the listing, hoping to reset the MLS, a new listing the same day or the next day, it will not work. It will still show however long it's been on the market. It will have to be off the market for 30 days in order for that to comply. So the days on market will still increase if it's an active or backup status. It will pause if it's an active no or off market, active no showing, formally off market, withdrawn or under contract. That's when the days on market will pause. And it resets if the C of O is issued. It's not on the MLS for longer than 30 days, or if it gets listed with the new brokerage. So it's listed with ABC brokerage, and that agent, or not, doesn't have to, but they were listed with ABC brokerage, and now their listing was canceled or expired, and they want to list it with our brokerage. And so it was on the market yesterday, but it was canceled, and now it's going to be with our brokerage. The days on market will cycle over because it's a new brokerage, new opportunity, and it'll be taken care of at that point. Okay, does that everyone understand what is going to happen?
Yes, but the history will still be there. Like when you click on the
Yes,
history
if you
button.
click on history, you'll be able to see that it's been on the market. Yes. Let me explain now. I'm going to go to this and explain kind of the reasoning for it. The main reason for it is, quite frankly, the agent and the consumer are trying to manipulate their listing. They're ultimately trying to give the appearance that the home is a brand new listing, when in reality it's not. It's been on the market for a month, 2 months, whatever. And the agent is trying to do something to present or mislead the general public what's happening. And so not only is the change going to occur, but I know that the conversation is being discussed. If people still tried to do this, would this be considered an ethics violation? And I don't know if that would happen or not, but I at least wanted to have you look at Article 12 of the Code of Ethics and how it could apply. So under Article 12, it says realtors shall be honest and truthful in their real estate communications and shall present a true picture in their advertising, marketing, and other representations. So if you drill down even further under the standards of practice, this is the Article 12, that's the general statement. Then they kind of break things down even more to give you a little bit more idea. But remember, if you're in violation of the Code of Ethics, you're in violation of the article as a whole, not the violation of standard and practice. This is just a guideline, but you're in violation of this. So this opening paragraph already defines the language that it's not a true picture of their advertising. But then we go, but let's just go into standard practice 1210. Realtors' obligation to present a true picture in their advertising and representations to the public includes internet contact posted and the URLs and domain names they use, and prohibits realtors from manipulating, presenting content developed by others, listing and other content in any way that precedes or deceptive or misleading result to otherwise mislead consumers. That's the key gist of this. So people are relisting their listings in order to mislead the public. So not only ultimately this could be a ethics violation, and just wanted to make that be known. So hopefully you can see the reason why the MLS is going to be making that change is not only good for everybody, but it also eliminates just this kind of bad behavior that is existing. And any experienced, I would have to say, you don't even have to be very experienced. You should know that when the CDOM says 90 or 120, but days on market says 12, it's probably not a new listing. Something came up that is a little bit misleading. So hopefully you now understand that kind of why that's there and what's taking place. But that's really kind of the gist of what I wanted to talk about today. What questions do you guys have in reference to anything that we talked about today? And if there is nothing, I guess now I would open it up if there's any further questions that you guys may have that you would like some assistance with.
This was really helpful, Rob. This is really good to explain that. Thank you.
You're welcome.
I have a question really quick.
Yeah.
If a house is under contract and then somehow gets canceled and goes back on the market, does it show up as back on the market, or how does that affect the days on market?
So let me share the screen again. A second. Okay, so let's go back to so when it's under contract, those days on market will stop calculating. So let's say that it's been on the market for 14 days and it goes under contract for 10 days. So technically from if you added all those days up, total days on market, you could say are actually 24. But when that under contract failed and now goes back on the market, it's going to start clicking again after day 14. So the next day that'll show is day 15 instead of day 25. Does that make sense?
Yeah, thank you.
Okay. Any other question? And that's the same already the way it is. That won't be any different.
I have a question about agency.
Okay.
So in a scenario where a buyer has a realtor and the buyer finds out who the seller is, and the seller is actually the listing agent, and the buyer reaches out to that listing agent, should that listing agent refer the buyer back to their buyer's agent to negotiate, or does that listing agent have the right to negotiate with that buyer?
Okay, let me make sure I understand your question. So you're saying the seller is not only a seller, but they're also the listing agent.
Correct.
Okay. So, and now your question is, if a buyer reaches out to, they think as the seller, does the seller have the right to negotiate without the buyer's agent? Is that
Correct.
Okay.
And especially where that seller is the seller's realtor, they're their own realtor.
Okay.
Should they be negotiating with that buyer?
So let's break it out. I'm going to answer the question. It's kind of a two-part answer. So the first answer is we're talking about agency. And in this case, the seller is an agent. So they have knowledge that if an existing agency relationship exists, then they cannot interfere in an existing agency relationship. So that listing agent should be obligated to tell that buyer, hey, I'm unable to negotiate or talk to you about this. You've got an agent already. You need to make sure that you go back and talk to your agent. Now, if it was just a seller who is not an agent, they obviously don't have that knowledge, and they should still refer the buyer to go back and talk to their agent versus having the negotiation. But of course, they may not have the understanding, and they may just, out of ignorance or just lack of knowledge, they may just start negotiating on their behalf. Now, the only way that listing agent would be authorized to negotiate with the buyer directly is if they received written authorization from the buyer's broker that it is okay to make that to have that negotiation.
Okay.
Does that make sense?
Well, that's what I thought. But I just wanted to be clear that is correct.
Yep. Now, it doesn't mean that the agents follow that. That's the requirement.
Yeah. And then what happens when they don't follow that? And they send you a text saying that they're going to send an addendum over.
Yeah.
Because they had spoke with your clients.
Okay. So now if that happens, we have then the obligation to stop the behavior first off. So if that happened, it sounds like it may have happened to you, Jeanette, or something close to it. I would say immediately, I would be as the buyer's agent. I would reach out to that seller or that listing agent, and I would make it very clear that they are not authorized and they are required to immediately stop all communication with my client, and any communication about the negotiation of the offer it must be done through me. And I would have that done in writing. And then I would see the rest of the transaction. And after the transaction were to close, then at that point, I would consider whether or not I was going to file an ethics and a division complaint.
Okay. I've done the first thing. I made it clear.
Yep. Just make sure it's done in writing, and, get something in writing to verify that what you're accusing them of actually did occur.
Is a text message in writing?
It is in writing. It's just sometimes not the easiest to try to work with. So email still is a lot more, is the better approach, but a text message can still be used. Okay. Did that answer your question?
Yes, thank you.
Okay. Anything else? Any other issues? And if not, okay, we'll go ahead and kind of make a shorter phone call and say again, make sure that please reach out to Jason or myself anytime that you feel like you need some answers to some questions. Obviously, those of you that are on these calls are typically the ones that have a better understanding of what should and shouldn't be done. It's the ones that are not on this call that we probably end up having the problems with. So continue to get the word out so people will jump on this. But thank you so much for joining, and enjoy the rest of your day.
Thanks, Rob.
Okay,
Thank you. Have a good day.
you bet.
Yeah,
Bye-bye.
thank you, Rob. They're very informative and beneficial. My silence is just agreement.
Well, thank you so much.